The 14th Amendment, Enforcement Clause, by Ern Kamerinsky and by Earl M. Miles. Section 5 of the 14th Amendment vests Congress with authority to adopt appropriate legislation to enforce the other parts of the amendment, most notably the provisions of Section 1. As Senator Jack M. Howard explained, Section 5 enables Congress, in case the state shall enact laws in conflict with the principle of the amendment, to correct that legislation by a formal congressional enactment. By adding to the authority Congress, Section 5 changes the balance of power between the state and the federal governments. That is a hallmark of the federal system. Scope of the power conferred by this provision has been a matter of considerable controversy. Initially, the Supreme Court gave a broad interpretation to Congress's authority under Section 5. Ex parte Virginia, 1879, the court declared, whatever legislation is appropriate, that is adapted to carry out the objects of the amendments have in view, whatever intend to enforce submission to the prohibitions they contain, and to secure to all persons the enjoyment of perfect equality of civil rights and the equal protection laws against state denial or invasion, not prohibited, is brought within the domain of congressional power. However, subsequent divisions have in time construed Section 5 power more narrowly. These decisions have focused on two primary issues. First, who may Congress regulate? Second, what may Congress do? The debate over these issues that began in the late 19th century continued to the present day. First, who may Congress regulate? In the civil rights cases, 1882, the Supreme Court struck down the provisions of the Civil Rights Act of 1875 that outlawed racial discrimination in a variety of private transactions, noting that Section 1 by its terms limits only the power of the states, and that therefore Section 5 should not be read to provide Congress with the authority to regulate the activity of purely private parties. The court declared it does not authorize Congress to create a code, municipal law for the regulation of private rights, but to provide modes for redress against the operations of state laws and the actions of state officers. By contrast, United States versus Guest, 1966, six justices, although not in a single opinion, conclude that the Section 5 empowered Congress to outlaw private discrimination. In some circumstances, however, United States versus Morrison, 2000, the Supreme Court held that Congress did not have the power under Section 5 to enact a law called the Violence Against Women Act, which allowed victims of gender-motivated violence to sue the perpetrator in federal court. This decision expressively reaffirmed the civil rights cases and disavowed the opinions to the contrary. In Guest, the court declared that it was reaffirming the time-honored principle that the 14th Amendment, by its very terms, prohibits only state action. Second, what may Congress do? More specifically, does Section 5 allow Congress to prohibit actions by the state governments that will not be outlawed by Section 1 itself? The Supreme Court has answered the question differently over time. At one point, the justices expressed the view that Congress can use its power under Section 5 to expand rights, as well as to provide remedies for violations. Thus, in Kensbach versus Morgan, 1966, the court held that Congress could rely on Section 5 authority to outlaw the use of literacy tests as a qualification for voters while being educated in Puerto Rico, notwithstanding the fact that only 7 years earlier the court had found that the use of literacy tests did not violate the 14th Amendment. The majority opinion concluded that Congress had the power to expand but not limit the rights that would otherwise be protected by Section 1 of the 14th Amendment. In subsequent cases, however, the court has held that Congress cannot use its powers under Section 5 to expand rights, but rather only to provide remedies for rights recognized by the courts. In Oregon versus Mitchell, 1970, a deeply divided court held that Congress could not constitutionally require the states to allow 18-year-old citizens to vote in state and local elections. Most importantly, in City of Bourne versus Flores, 1997, the court held that Section 5 does not empower Congress to create new rights or expand the scope of rights, and that even laws designed to prevent or remedy violation rights recognized by the Supreme Court must be narrowly tailored, proportionate, and congruent to the scope of constitutional violations. City of Bourne involved the Federal Religious Freedom Restoration Act, RFRA, a law adopted in 1993 in response to a Supreme Court decision that had narrowed the protections of free exercise clause of the First Amendment. In essence, RFRA subjected the actions of state and local governments to the same level of scrutiny that have been applied in earlier Supreme Court decisions interpreting the scope of the clause. However, the City of Bourne majority concluded that this part of RFRA was unconstitutional because Section 5 does not authorize Congress to either create new rights or expand the scope of the rights recognized by the court itself. Similarly, in Shelby County, Alabama versus Holder, 1913, the court declared key provision of the Voting Rights Act of 1965 unconstitutional because it exceeded the scope of Congress' power under Section 5 of the 14th Amendment and Section 2 of the 15th Amendment, which grants Congress power to enforce the 15th Amendment. That provision of the Voting Rights Act requires certain state and counties with a history of race discrimination in voting obtain approval called preclearance from the United States Attorney General or the federal court before changing their election system. For example, enacting a law that requires voters to show identification. The act included a formula that determines which state and counties need to get the preclearance to change their election practices. Only some states and counties are required to seek approval before changing election policies based on their history of discrimination in voting. When the Voting Rights Act was passed in 1965, the preclearance provision was set to expire after 5 years. The life of the provision was extended by statute in 1970, 75, and 1982, and then for an additional 25 years in 2006. In Shelby County, the court determined that the 2006 extension was unconstitutional because the formula for determining which state county is required to seek preclearance before changing election practices was based on data about racial discrimination from 1970s and had not been changed since 1982. Under these circumstances, the majority conclude that the selective imposition of the preclearance requirement run afoul of what is described as a fundamental principle of equal sovereignties among the states. Thus, under current law, there are two key limits on Congress' power under Section 5 of the 14th Amendment, both which are controversial. First, Section 5 does not empower Congress to regulate private conduct, but only the actions of state and local governments. Second, Section 5 does not provide Congress with the power to create new rights or expand existing rights, but rather only with the authority to prevent or remedy violation rights already recognized by the courts. Moreover, the remedies provided by federal statutes must be proportionate and congruent to the scope of proven constitutional violations. Matters of debate. The first perspective. Congress has broad powers under Section 5 of the 14th Amendment by Erwin Chemerinsky. Section 5 of the 14th Amendment should be interpreted broadly to authorize Congress to advance the protections of due process, equal protection, and the privileges and immunity of citizenship. The drafters of the 14th Amendment intentionally chose not to leave the enforcement of its provisions solely to the courts, but instead give Congress authority to enact laws to enforce its requirements. The history of the 14th Amendment shows that its framers intended Congress to have expansive power under this provision. The first case to interpret this authority after the ratification of the 14th Amendment. The court spoke of Section 5 giving to Congress the power to secure all persons the enjoyment of perfect equality of civil rights and the equal protection of the laws against state denial or invasion, and that any act, if not prohibited, is brought within the domain of congressional power. Ex parte, Virginia, 1879. According to Congress, such power is a desirable and necessary way of fulfilling the crucial goals of the 14th Amendment, protecting people from infringement of their rights or the denial of equality. The Constitution is the floor, not the ceiling, of individual rights. Congress should have the ability to expand liberty and enhance equality, and Section 5 should be interpreted to allow this. Unfortunately, the Supreme Court repeatedly has adopted unduly narrow interpretations of Congress's power under Section 5. First, the court wrongly held that Section 5 does not empower Congress to regulate private conduct, but only state and local government's actions. So initially, the holding in the civil rights cases in 1882 and reaffirms in United States v. Morrison 2000, which held that Section 5 did not give Congress power to pass a law prohibiting private gender-motivated violence. The court reasoned that because Section 1 of the 14th Amendment, which prohibits states from denying citizen privileges and immunity of citizenship, due process, or equal protection of the laws, applies only to state and local governments. Congress's power to enforce the 14th Amendment is similarly limited. But then conclusion does not follow, as Justice Stephen Breyer expressed in his dissent in Morrison. But why can Congress not provide a remedy against private actors? These private actors, of course, do not themselves violate the Constitution, but this court has held that Congress at least sometimes can enact remedial legislation that prohibits conduct which is not itself unconstitutional. Moreover, violations of rights by private actors occur precisely because state and local governments have failed to prevent them. Congress, in preventing discrimination or violation of rights by private entities, is remedying the failures of state and local governments. This is exactly what the power under Section 5 exists to accomplish. Second, the court has unduly limited Congress' power to protect liberty and advance equality under Section 5 of the 14th Amendment. In City of Bourne v. Flores, 1997, the court ruled that Section 5 does not empower Congress to create new rights or expand the scope of rights. Rather, Congress is limited to laws that prevent or remedy violation rights recognized by the Supreme Court, and this must be narrowly tailored, proportionate, and congruent to the constitutional violation. It significantly and unjustifiably limits congressional power. Applying this test, courts have declared unconstitutional federal laws expanding protection for religious freedom, making state governments liable for age and disability discrimination in employment, and allowing state governments to be sued for patent infringement. The Federal Rule of Congress Section 5 power was articulated in Kensingberg versus Morgan 1966. The court concluded the Congress has the power to expand but not limit the rights that would otherwise be protected by Section 1 of the 14th Amendment. This approach accorded Congress the power to expand the protection of liberty and equality, as well as to prevent remedy violations rights recognized by the courts. Third, the court has wrongly restricted the Congress' authority to impose remedies on states with a history of race discrimination in voting. In Shelby County, Alabama versus Holder, 2013, the court held that a section of the Voting Rights Act of 1965, the subjects certain states counted to heightened anti-discrimination measures, is unconstitutional, as it exceeds the scope of Congress's powers. It is an impermissible intrusion on state sovereignty. The Voting Rights Act of 1965 is a landmark civil rights law. The law prohibits state and local governments from having election practices which discriminate or have a discriminatory impact against minority voters. It authorizes lawsuits to enforce this prohibition. Congress, though, was concerned that it was not sufficient. Litigation is expensive and time-consuming. Also, Congress was aware that many jurisdictions, especially in the South, were repeatedly changing their election practices to discriminate against minority voters. Congress, therefore, included a preventative measure. Another section of the Act says that jurisdictions, states, and counties with a history of race discrimination in voting must get preclearance from the Attorney General on a three-judge court before significantly changing their election systems. For example, adopting laws that restrict early voting. The Act includes a formula defining which jurisdictions must get preclearance. Congress repeatedly reauthorized the preclearance requirement, including for 5 years in 1970, for 7 years in 1975, and for 25 years in 1982. In 2006, Congress voted overwhelmingly 90 versus 0 in the Senate and 390 versus 33 in the House to extend it for another 25 years, and President George W. Bush signed this into law. In Shelby County, Alabama was the holder. The Supreme Court, in a 3-4 decision, held that as a formula in the Voting Rights Act defining which state and counties have a history of discrimination in voting, and as therefore required to get approval before changing the election systems, is unconstitutional. It effectively notified preclearance requirements under the Act, but it is unclear what constitutional provision or principle the court found was violated by the Voting Rights Act's formula for determining which state and counties have a history of racial discrimination, and therefore subject to heightened anti-discrimination measures. The closest the court came to indicating this was by saying that Congress violated the principle of equal rights, equal state sovereignty, that it must treat all states alike. Nowhere, though, does the Constitution say that, and the framers of the 14th Amendment obviously did not believe this, since they also passed the Reconstruction Act and imposed military rule over southern states. This was the first time since the 19th century that the federal civil rights law dealing with race was declared unconstitutional. States immediately implemented voting laws that has been blocked by the Attorney General as discriminatory. In all these ways, the Supreme Court has improperly limited Congress and denied it the broad authority it should possess under Section 5 of the 14th Amendment. The next perspective. The power to enforce Section 5 of the 14th Amendment by Earl M. Moutz. Without question, Section 5 of the 14th Amendment changes the structure of a federal system. By its terms, its provision plainly vests Congress with the authority necessary to prevent state governments from invading the fundamental rights of the American populace. Nonetheless, the legislative history of the 14th Amendment belies the argument that Section 5 was designed to allow Congress to either define the scope of the rights protected by the amendment or declare that a specific legislation constitutes an appropriate means to protect rights that are within the purview of Section 1. The 14th Amendment, of which Section 5 was a part, was intended to provide a detailed outline of the conditions on which the Republican Party would allow the states that have joined the Confederacy to regain their standards as full partners in the Union. As such, the provisions of the amendment were intended to embody policy judgment, which could be supported conscientiously by all mainstream Republicans. Throughout the process of drafting the amendment, racial Republicans were forced to make a variety of concessions to the more conservative and moderate compatriots in order to maintain the necessary unanimity of support from party members. The need to preserve party unity provided the background for the drafting of Sections 1 and 5. Immediately, racial radical Republicans such as Senator Charles Sumner of Massachusetts had no qualms about constituting power in the federal government, but while many less radical Republicans agreed that Congress should be empowered to protect a limited set of fundamental rights, they also remained committed to the idea that the federal power should be kept within fairly narrow limits. The strength of this commitment was clearly reflected in discussions of a precursor to Section 5 that has been proposed by the Joint Committee on Reconstruction in Federal 1866. The committee proposal would have armed Congress with the power to make all laws which shall be necessary and proper to secure the citizens of each state all privileges and immunities of citizens of the several states, and to all persons equal protection of the rights of life, liberty, and property. This measure was effectively defeated because it was opposed not only by Democrats but also by a number of mainstream Republicans. None of the Republican opponents expressed any concerns about the scope of the proposed privileges and immunities clause. Instead, all complained that the adoption of the equal protection language would have unduly expanded the powers of Congress. In apparent response to this objection, the final version of the 14th Amendment replaced the phrase equal protection of the rights of life, liberty, and property with the equal protection of the laws, language that had a well-established legal pedigree in the 19th century. But despite this change, those who argue for an open-ended reading of Section 5 essentially contend that in June 1866, the mainstream Republicans who served in the 39th Congress unanimously and consciously embraced the same wide-ranging expansion of federal power that many had rejected less than 4 months before. This contention is simply implausible if in fact Section 5 of the amendment reported by the Joint Committee in June had been so understood. One would have expected to have heard at least some comment from those Republicans who had so vigorously opposed a broadly worded version that was proposed in February. But in reality, no such comments was forthcoming. While a mainstream Republican of all stripes freely expressed their dissatisfaction with the basic forms of Section 2 and 3 of the proposed amendment. Republican criticisms for the potential scope of Sections 1 and 5 were noticeably absent. Against this background, one can only conclude that those Republicans who fear that the broadly worded version that has been debated in February would unduly expand the scope of congressional authority had no such apprehensions about the principles that were ultimately embodied in the 14th Amendment itself. In short, the weight of the evidence clearly supports two principles that limit the extent of the power granted to Congress by Section 5 of the 14th Amendment. First, Section 5 was not designed to give Congress the power to redefine the concept of fundamental rights. Second, congressional power to devise remedies for purported violations of Section 1 should also be subject to significant limitations. Of course, difficult line drawing problems might still arise in some cases, but those who argue that Congress should have almost unfettered power to expand the protection of the 14th Amendment misconstrue the import of the enforcement clause.